persons may get are fever, headache, joint, and muscle pains. The illness is often resolved through rest and adequate hydration along with paracetamol to treat the accompanying fever. However, on occasions, the illness can progress to severe dengue, which can result in organ failure, bleeding, and severe fluid depletion that can lead to shock and even death. Therefore, it is important for persons who are experiencing fever, vomiting, severe abdominal pain, bleeding under the skin, feeling very weak, or getting confused to seek immediate attention. Let us work together to protect ourselves against dengue.
Do you wish there were a way your community could get funding to improve a school, health center, sports program, and more? There is! It's the Constituency Development Fund. Here are a few things you probably didn't know about the CDF and how you can make it work better for you. The CDF policy promotes citizen participation in community development and the protection of taxpayers' funds. It outlines that MPs
a very important matter to do with our children. Guide our deliberations, O Lord. Guide our presentation. Allow it to be swift and very clear and instructive. We thank you once more for giving us this day. Amen.
Hi, okay, good. Thank you very much, Julia. Any apologies for absence? No apologies for absence, but I would like to welcome the technical team who are here. Also, Minister Dalrymple, who is in the present, but a number of members are now joining us virtually. So I'm going to just check to find out who is on virtually. Is MP Jess on? Can you just show us your face? I see Senator Scott Motley, you're on?
Good morning, Chair. Good morning to the team. I am on.
Wonderful. Senator Golden Campbell, are you on?
I too am here.
Okay, very well, Senator Shereen Golden Campbell. Dwayne Smith, are you on? MP Dwayne Smith?
Yes, Chairman, I'm on.
I think Donovan Williams, are you on? You can just tell us. Member Donovan Williams, can you hear?
Yes, Mr. Chair, I'm on.
All right, wonderful. So,
Sunita Chairman, I'm on.
Okay, Member Jess. All right, so we're going to, there's a minute, but apparently this last minute was only issued early this morning. This is April the 9th, so we're not going to take it now because obviously members may not have had a chance to read it. But this would be about the 4th minute, Mr. Nash, that we have outstanding. Did we pass the last set? Well, the previous ones were passed? Yeah. All right, very well. So what we're going to do is to continue now with the outline and discussion on the matrix, and we do the overview almost at the same time. I'd ask members to look at the matrix. They come in two forms. I mean, there are two, they go from pages 1 to 59, but there are two sets, okay? So members should make note of it. All right? Now, we're going to turn over, and persons who are online, just bear in mind, if you need to ask a question or to interrupt, just put up your hand, and then I will allow you to come in to participate. So although you're online and not here, if you just do the hand raise, and then give me a few seconds before I allow you to intervene, persons online. So we are going to begin now with the consideration of the overview and the matrix. And I turn over now to you, Ms. Wigan, and then you and Ms. Cole-Jarrett, you can enter. So Let us know what page we're starting from. Part 1.
Yes. Good morning once again. We would have completed section 2, and so we're now at section 3. That's
Could you give us the
objects
page?
and application of the act. It's page.
So we're at page 10.
Of the matrix. Is it page 11? I'm
Okay.
in trouble. So we're at page 10. On my version, it is page 11. And so I was asked by the chairman to just do a synopsis or summary of the submissions and identify critical theme areas and to reference the pages in terms of details. So for the objects and application of the act, there was a general consensus from all 5 stakeholders who commented on that section of the act. They proposed that section 3 be amended to strengthen this provision, to look at rehabilitation, reconciliation, prevent stigmatization, and ensure alignment with the principles of diversion. The 5 stakeholders who would have presented are Jamaicans for Justice. On your part 2, pages 13 to 14, they would have provided details. The Children's Advocate, part 2, page 13, who spoke on the alignment of the diversion principles vis-a-vis children with behavioral challenges. Then we have Jamaica Umbrella Group of Churches, on your schedule, part 2, page 13, who recommended that there should be reform with a focus on application and not abolition. The Ministry of Justice and Constitutional Affairs, on part 1 of your schedule, pages 10 to 11, looks at the limitation of the application of the act beyond a child in conflict with the law. And the last, the Ministry of Education, Skills, Youth, and Information, part 1, on your schedule, pages 10 to 11. And they looked at they indicated that we should include a provision that treats with prevention of stigmatization, discrimination, and other adverse effects. As it relates to sections 4, 5, 6, and 7 of the Child Diversion Act, that looks at the establishment of the Child Diversion Office and its function, and the Child Diversion Committee and its function. 7 stakeholders would have made their submissions, and they all had consensus to clarify the roles and functions of the Child Diversion Office and the Child Diversion Committees to avoid overlap, interagency coordination, improve governance, etc. If you look to your part 1 of your schedule, pages 12 to 12, 16 to 17, the Ministry of Justice and Constitutional Affairs would have generally provided its feedback, asking for a review to allow for better coordination of the efforts and to amend section 7F, subsection 1I, H, and G. The Ministry of Education, Skills, Youth, and Information, on pages 11 to 17 of part 1 of your schedule, also commented on the fact that the functions seem to be overlapping and asked to have a review to have a clear distinction between the operations and the role of the Child Diversion Office and the Child Diversion Committee. The Ministry of National Security and Peace, on part 1 of your schedule, pages 12 to 13, express provision for the Child Diversion Office to be mandated to liaise with relevant law enforcement agencies, establish structured case management and oversight mechanism. And the Jamaica Coalition for a Healthy Society, on part 1 of your schedule, pages 12 to 13, indicated that there is a need to publicize the value of abstinence and adverse effect of early sexual activities.
Before you continue, maybe I could ask Ms. Clark, who is in charge of the child diversion, could you please explain the relationship for us, the committee members, between it. We have a child diversion officer in every parish. We also have a child diversion committee in every parish. Could you just explain the role, how they interact?
So good morning, members. So the child diversion office in every parish is staffed with an officer who is the one who attends court or goes to the police stations. They receive the referrals. They conduct the intake assessments, the risk and needs assessments, and present those to the child diversion committees.
So if a child is being referred by the court or by the police, it's the child diversion officer who gets that referral first.
Yes.
And now how does the child diversion committee comes into play?
So the child diversion committee has members from the Department of Correctional Services, Justices of the Peace, JCF, and so on, CPFSA. So all of these members come together, and once the treatment plan is presented to them, they can review and determine, is this suitable for this child from the risk factors that we've identified. They can also make recommendations for amendments or modifications to the plan. They also, when the child is complete with the program, they sign off on the completion, and if modification needs to be done or the matter has to be returned, the committee has to sign off on that as well.
So before the child start engaging in a program, the child diversion committee of the parish has to do an assessment. So you said that you have members from CPFSA. Members, they're here today? From the Ministry of Education? They're not here today? But you have someone from the CPFSA who sits on that committee. So if the committee itself could say that this is a matter that could be referred to CPFSA, or?
Usually before it comes to us, the court will determine where it goes. So if it's for a child that is exhibiting behavioral issues, generally that is referred to CPFSA. If it's extreme situations, then the matter comes to us. But what the committee allows us to do is for all the parties that are involved in the protection of children to be involved in the treatment planning and the approval of the plans that are presented for the child that is coming.
And it is also this committee that makes recommendation as to whether or not the child needs immediate psychological support?
Yes, so we have a tool that is used. So all the officers have the risk and needs assessment is the same, and it allows us to identify the child's risk level. Once the risk level is identified, that is presented to the committee to indicate this is the risk level of the child, low, medium, or high, as well as some of the factors that were identified. Once those are presented to the committee, then the committee, because they also have psychologists on board as well, can indicate, okay, we believe that this is a sufficient treatment plan for this child, or they can recommend additional interventions to include on the plan.
How is a mentor determined as to, how does the child get a mentor? Say, we have trained a number of mentors across the island. Who decides on the mentor for that child?
So that is a discussion that is had again with the committee. Initially, it is the initial recommendation is made by the officer, but once it goes to the committee can then say, for example, if it's a young boy who is not responding positively to the female interaction, the committee can then recommend that try to find this boy a male mentor, or they can recommend different mentors from different fields.
Mm-hmm. So in terms of the child, now what about the correctional services? During the discussions over the past few occasions, we heard that some of these children were actually in institutions.
Yes.
How does the committee interact with the correctional services?
So there's a member from the Department of Correctional Services on all the parish committees, So, but outside of that, if the officers want to go into the facilities, they will speak with the superintendent and make arrangements so that when they get there, they're allowed access.
Have you had over the last few years any situations in which the child remains in the institution and is under the child diversion treatment plan? Or do you once, if the child is in an institution, which has occurred, do you remove them from the institution before you start the program, or do you continue with the child even though the child is in the institution?
It depends on how long they're in the institution for. So if they're there for, let's say they're sent from Westmoreland and they're in remand for 30 days, we will wait until the child gets back to their community. If not, and it's for an extended period, we try to provide the interventions at the facility. That is a challenge though, because the whole idea is for them to not be in a facility, so it poses a challenge.
Okay, I want to welcome the, sorry.
That it's the court that decides whether the person goes into a facility or is out. Am I correct?
Yes. Sometimes, just for clarity, the court makes that decision based on the request of the parent as well. So it's not necessarily just saying, if a parent believes that the child is violent and they're not able to treat with the child and cannot, manage the child, they'll ask the court to hold that child.
So you see, we're looking at assessment of the child diversion committees in the parishes. Truth of the matter is that not many people are aware of the existence of this committee, and that is why I'm interrogating you a bit to get it out that really is not only the child diversion officer who gets the report, a referral from the police and the court, and then they start the treatment. What is not open to the public and to the committee members is that nothing is done to the child in terms of a treatment plan until the child diversion officer who gets the referral take the referral to the committee. Yes. And it is the committee that looks at the assessment and determine, firstly, whether it should get mentoring, whether they should get psychological support. Anything else the committee does, Ms. Clark?
So that's mainly the approval, the vetting of the treatment plans as well, making suggestions for modification, and once they've completed the discharge process.
I want to welcome the officers from the CPFSA. To the best of your knowledge, are you aware that all of the parishes have representative from your department on the Child Diversion Committee?
Could you repeat that for us, Minister?
We're looking at the Child Diversion Committee, and it's being assessed, and if you see some of the recommendations are about looking at what the Child Diversion Committee does. But it is not obvious that the treatment plan for a child who was committed an offense, that it is not just referred to the Justice Center where the Child Diversion Officer is. It actually, having been referred to the Child Diversion Officer, the Child Diversion Officer develops a plan based on what the committee assess. And the Child Diversion Committee consists of a number of about, how many persons normally, Ms. Clark? Usually about 7 members. A minimum of 7, maximum of 11, but to the best of my knowledge, they have representatives from the correctional services, a psychologist, a member from CPFSA. Could you tell us who are the other members normally in the Child Diversion Committee, Ms. Clark?
So it says a Justice of the Peace, a probation and aftercare officer, a Minister of Religion, a qualified guidance counselor, a member from the Jamaica Constabulary Force, an education officer, a member from the government agency responsible for children, a person qualified in child psychology, registered medical practitioner in child psychiatry, such other person who appears to be qualified in matters including criminology, human behavioral science, social science, drug abuse treatment, which are relevant to addressing the needs of children in conflict with the law.
And to the best of your knowledge, Ms. Clark, is a regular report brought to the Child Diversion Committee from the Child Diversion Officer?
Yes, they have to. So every meeting that they have, in order to approve a treatment plan or for a child to move from completing all the requirements and being discharged, those have to go back through the committee as well. So on every occasion that they sit, they're updated on matters. And say, for example, there's a case management issue that they need clarity on, or a child has been referred and reoffended, the matter has to go to the committee for the discretion to be discussed if the child will be continuing the program or they will be returned.
All right, CPFSA, you're aware of, to the best of your knowledge, do you also get reports regularly from the parishes, their child diversion committees?
To the best of my knowledge, to the best of our knowledge, Minister, no. We are not aware that we get regular reports in that instance unless there's a child before the court that we also have an interest in. So, for example, if the child is a ward of the state, so we represent wards of the state in criminal matters before the court. So unless there's a ward of the state before the court, we're not usually privy to individual reports from the committee regarding certain children.
No, let me just ask you, CPFSA, do you do the sort of individual assessment and treatment of persons referred to your department?
Certainly.
I mean, you have psychological reports, etc.
Certainly. So we go through our CFSU program. So we have that kind of assessment for children. Once they are referred to us, once they're in our care, then we have that kind of treatment. Psychiatric, psychological, all of that kind of treatment is given to them once they're in our care.
Right. You see, why I'm asking these questions is we don't want a complete overlap. You see, we want the CPFSA and the Child Diversion Committee to be close, working together. Now, the success, as I understand it, of the Child Diversion is because you have this committee that does a full assessment of the child and maps out a treatment plan for the child. Isn't that my understanding, Ms. Clark? And then over 4 to 6 months period, it monitors the child on a regular basis.
So just for clarity, Mr. Chair, the assessment is conducted by the child diversion officers.
Right.
They all use the same tool, though, and the results are shared with the committee, and they make an assessment from there to determine if additional interventions are required, or our intervention needs to be removed from the plan, or modification is required, and so on.
Yeah. You see, CPFSA, I mean, you tell me a huge body, of persons. So we really want to ensure that only the really needed cases actually come to child diversion. And in the act itself, it literally said that only if a person has committed an offense. Now, what we would want is for the police, especially the police, and the clerk of court or the DPP, in cases where, well, especially the police, where a child is engaged in delinquent behavior, whether it is appropriate to send it to CPFSA or in really bad cases where you really need specialized treatment, maybe they send it to the child diversion office. So one of the things we really want to work with CPFSA, that deviant delinquent behavior really should be a part of the CPFSA mandate. But in those cases where it's bordering on really serious delinquent behavior and the commission of an offense, that the police or the DPP send it to the child diversion office. Yes, member.
I'm curious. You have a full complement of people on the committee. Are they mandated to meet how often? And otherwise, apart from matters that are referred to you, from court, does the committee have a sense, or how do they get a feel of what is taking place in the parish without a court referral? I mean, it's a great committee with psychiatrists. I'm just wondering just how often are they mandated, and how do they know apart from a court referral?
The committees meet at least once per month for most parishes because of the referrals that come in. Outside of that, though, the chairperson, can request a meeting to, discuss other matters relating to incidents in the parish as well. But usually the updates for the parish activities, they are provided by the parish officers. So they all have the contact and so on for the parish officer.
Okay. Because you see, because you have such an excellent structure, sometimes, and if you're supposed to function efficiently, and I don't know whether or not members of the committee are compensated in any way, but they are? Well, if they are, I would suggest that there should be some way of reaching out, so that sometimes the child that gets to court wouldn't have to get to court if there's a program to reach out. Because even as you say that there's one in every parish, in Trelawney, I'm not aware.
Well, this is the concern you say I have, member.
Yes,
that we hear about child diversion, and we know it is a success. But the country and, people do not know who is behind the success. It is, although we have, a lot depends on the child diversion officer. There's no doubt about that. But the child diversion committee, which consists of outstanding personnel, they're the ones who, monitor what is happening. And colleagues, if you look at section 7, the functions of the child diversion committee, it is extensive. And I mean, they're the ones who really don't get, the sort of compliment that, sorry.
Chairman, their success really depends on their reach within the community. So it doesn't matter how well manned they are, success can only be truly achieved, and persons can only be aware of the committee if they have their fingers and feet everywhere, so that people know. Because I am positive that people are not aware of this facility, and if they are compensated, and there has been so much effort put in by the Ministry of Justice, if you have them on a committee and they are compensated, I think it is important that they get in, because you have community meetings. In your community meetings, somebody from the community should reach out in some areas to say, okay, you're having a meeting, I want to come and tell them that there is a child diversion committee. I really think it is important.
Why I'm raising this point again, we have some serious problems with children, not only in our schools, but across Jamaica. And you see, this child diversion committee, should work, should I say CPFSA, should work closely with the child diversion committee to see how best policies can be developed to stem the indiscipline that is cutting right across the schools and across many communities. So you see, CPFSA, I'm going to beg you to look at Section 7 of the Act, which is what we are discussing now. But most importantly, to check and see which one of your officers sit on these parish child diversion committee. I must admit, the National Child Diversion Committee has not really functioned, right? Because we have been dependent on the parish child diversion committees, which I know function because they are in constant assessment of persons who have been referred. But, Ms. Clark, I'm going to beg you to make sure that CPFSA, that they are in constant touch and report back to your ministry. You see, the CPFSA representative as to what is happening. And they can also assist in looking at how the parish committees can function better. Because one of the things where we hope after these assessments is that children who have committed serious offenses or that they're referred directly to the child diversion officer either by the police or by the DPP or clerk of court. This is what the DPP has indicated, without the child having to go to court. In other words, we are trying to keep children between 12 and 17 as best as possible away from the court, only where they don't cooperate, only in the most serious cases, or those cases which is not provided for in the Child Diversion Act, but the court could indicate that they can go to a child diversion. So, Samantha, we want to have a situation, which we mentioned last time, that referrals of children in who have committed offenses, that it is the police who could charge, but still refer them to the clerk, and the clerk could then send them to child diversion, or the DPP who would send them to child diversion. So once it is an offense in the schedule, then we don't want them to go to court. The DPP or the clerk should send them to child diversion. But if it is not in the schedule, then they may well have to be charged and let a recommendation go to the judge that this is not in the child diversion schedule because it's a serious offense, but the police or the child diversion or whoever could say to the court, this child could benefit from, a child diversion treatment, okay? So that's the only time I believe that the child should be taken to court. Even those so-called out of control, children, I would want them to go to child diversion rather than going to the court. So to the extent that the parent can take them to the police and urge the police, I don't know how we're going to work it out, but we need to work it out that we avoid our children going to court. That's the main thing. You want to say something, Mr.
I just quickly wanted to clarify that the area regarding the child diversion committees and the child diversion office itself, most of the work is done by the child diversion office.
Mm-hmm.
The committee, because of how it is composed, or comprised members of different areas, different professions, technically they wouldn't be able to sit and do all the intake assessments and so on. So they evaluate the work that is done by the child diversion office and make recommendations where necessary. So though the Act stipulates a number of things that they need to do, most of that is done by the child diversion officer.
And I understand, because it is the child diversion officer who has been trained and who, has to interact with the child. Because the committee doesn't interact with the child. It is the child diversion officer who interacts with the child.
Yes, in most situations, but we also train the committee members because we don't take for granted that they're coming in knowing how to treat with children in conflict with the law. So before they start going to the meetings and so on, they are all trained.
Wonderful. So this is Section 7 where really, and the recommendations, are being taken into account so that we can determine what sort of adjustment, if anything, could be done to Section 7. All right? Continue, Susan.
So we had 3 other stakeholders who would have provided comments on Sections 4, 5, 6, and 7. The AIDS Healthcare Foundation, Jamaica, they also... right, the AIDS Healthcare Foundation Jamaica, their interest is that diversion assessments should incorporate psychosocial and developmental circumstances that are affecting children referred to child diversion. They felt that the Act doesn't quite clearly emphasize that aspect of it. Daniel Christian on pages 15 to 17, part 2 of your schedule, he indicated that there needs to be an established national evaluation and public reporting framework. And Daniel Barnes on part 2, pages 14 to 16 of your schedule, he indicated that we really should establish school-based subcommittees which are complementary to the parish child diversion committees.
Could I find out from CPFSA, do you have disciplinary committees in schools?
We don't have disciplinary committees in schools because the schools would have their own oversight in terms of how they treat with these matters. Again, though, what I will say is that there are many times when parents will be having issues with their children for whatever reason, and they will bring these children to our offices for counseling, for some help, because we're now CPFSA, but a lot of people still call us CDA, right? So a lot of people will say, "May I care my pitney go down a CDA," right, for help. So in instances where we have children who, not necessarily wards yet, not necessarily on any order from the court, they are acting out, then we will intervene if the parents come and ask for assistance. But regarding in schools, schools usually have their own. What we do is that we provide support to schools. So in some instances, we will do our school visits and so on, and we'll provide some support to guidance counselors and so on when the need deans of discipline and so on when the need arises.
Now, this contributor, Daniel Barnes, made the point to see that all schools should have disciplinary committees. I think it's a good idea where, it could be chaired or the guidance counselor, but he thought that it would be useful to have a disciplinary committee that consists of, members of the PTA, the police in particular mentioned that the police should be on it. And the reason, I don't think this act should take that up, but I think CPFSA should. In other words, I think we have so many problems in our schools now that I'm going to suggest, and you discuss it with your ministry, I'll also discuss it with the minister, that you have disciplinary committees in the schools, that could assist. Because believe me, the little I've heard, far too many schools have serious disciplinary problems. Am I not right? So to the extent that you start out with some of those schools that have disciplinary committees where children with disciplinary problems could be assisted. I'm not saying the disciplinary committee is a tribunal for punishment, but a tribunal to assess what is happening in the schools and a lot of children are having disciplinary problems. That at that stage, CPFSA could intervene. You see the point I'm making? So I'm going to urge, it's a recommendation from one of the contributors here who feel you should have child diversion disciplinary committee. But in all sincerity, I don't think it should be the responsibility of the child diversion committee, but I do believe it's a good idea coming from a member of the public who in fact sits on a school board and thinks that all schools should have a disciplinary committee so children with disciplinary problems can get attention. You see the point? And that is where CPFSA should give those children attention. Okay?
Understandably so, Minister, and I do agree that we should have disciplinary committees within these schools. However, my reservation would be we are going back to the mandate of the CPFSA. The CPFSA is just but a fragment of the Ministry of Education. And so currently our mandate as we stand, we protect children, we empower families and so on, and we secure the future. And again, if we start focusing, while we have the resources to assist where necessary, for us to go into the schools and now be the agency to implement these committees in the schools, it may take away from, what our mandate is. Again, we are part of the Ministry of Education, and so we are here to render assistance where we can, but we're just but a fragment. And so in the circumstances of the formation of these committees, it may not specifically be CPFSA, but specifically forming these committees, but just assisting and being a part of these committees where we can to assist in the regulation of discipline in these schools.
Ms. Clark, you wanted to come in?
No, I was just saying from my understanding, Minister, the schools do have, I don't think they call it disciplinary committees, but they do have a board that will review matters, especially for expulsion and suspensions and so on. The school has those things in place.
No, I am aware of that.
That's what the minister is saying.
Yes.
No, it's not that. Because, yes, every school, you can't just get up and expel a child like that from school. It can be the principal alone that decides that there is a board. But I think what the minister is trying to say is that if you have, and I understand your mandate, but if you have the committees in every parish, it's not, you can go in and assist, because what you're trying to do is to help the child who is a little wayward in some way to catch up before he needs to go before a situation. And that is what I think the minister is trying to stress. And this is what it's all about, being able to catch up and let us become a more harmonious society before you get to the point where you have to now go and treat the problem.
You see, CPFSA, the recommendation came to us that we should have a child diversion disciplinary committee, but I don't think it should be within our act. Most of the activity of deviant behavior that occurs in the school is not something that child diversion office should take up. But I think CPFSA is the right body, or the Ministry of Education, and I will discuss it. They should have a committee that can readily identify children with behavior problems. And have an opportunity to, I'm not denying you have a guidance counselor, but 1 or 3 guidance counselors might not be able to succeed in a school of 1,000 more children. But it is something I'm begging CPFSA to look at, okay?
Yes, but if I may also say this, just going back to the function of the CPFSA and also where we intend to go. So the proposed amendment to the Principal Act, that is the CCPA, the Child Care and Protection Act, there's a proposed amendment, and I think I want to think that we had mentioned it last week, where there will be a direct recourse to the CPFSA for children with behavioral challenges, where the parent or guardian may make an application for those children to be assessed by our professionals, right? And then the treatment would be, applied thereafter. So last week, I believe I spoke about the therapeutic centers and the residential therapeutic centers and the non-residential therapeutic centers. So currently, what we have one non-residential therapeutic center that we work with children in. So again, there is currently a recourse, but it is going to, the hope is that the Principal Act is going to be amended so that parents will have that direct recourse to the agency. As I said before, there are many parents now who take their children to our offices in different parishes for counseling, and we offer that service, but it is not yet within the act for the direct recourse as yet. So that's what we're working on currently for that direct recourse to the CPFSA.
All right. I just want to stop there. And the reason I brought it up, because the contrary to Mr. Barnes. I mean, he came and he made that recommendation, but we want to give substance to it, to say it is not going to be in pursuance of
The Child
to the Child Diversion Act. We think it's appropriate to send it to the CPFSA Act. Okay? Thank you. Julia, you want to continue?
So we're at section 8 that speaks to the National Child Diversion Oversight Committee. We got feedback from 2 contributors, not stakeholders, I'm advised, to the Joint Select Committee, and they propose that we strengthen the monitoring, oversight, and reporting obligations of the committee to include regular meetings. The 2 contributors would have been the Ministry of Education, Skills, Youth, and Information, and the details of that information is in your schedule, part 1, page 17, and one of the Ministry of Education's recommendation is to ensure that there is a quorum requirement to be included in that section for the National Child Diversion Oversight Committee. The AIDS Healthcare Foundation Jamaica, on part 2 of your schedule, pages 18 to 19, they spoke to the need to strengthen the monitoring and oversight and to ensure, again, that regular meetings are held at intervals. As we look at section 9, which speaks to referral to child diversion program.
As you go along, yourself and Ms. Cole-Jarrett, if there are certain recommendations, point it out to the committee so we can either accept or reject, okay? As the case may be.
Right, so section 9, referral to child diversion program. There was a general consensus from all 10 stakeholders who recommended to the committee that section 9, the referral to child diversion program, be expanded and to strengthen the referral framework, and also to review the concept of consent as it relates to the children under the diversion program. Daniel Barnes, part 1, pages 17 to 23 of your schedule, recommended that we expand the access to diversion by increasing the referral authorities and have referral at different stages of the criminal process. He also asked that there be a structured risk-based referral system and that it should have a 3-tier classification of diversion offenses, and he proposed that this be introduced in a new second schedule to the Child Diversion Act. He also recommended to the committee that there be provided a post-charge diversion alternative to prosecution with expungible charges on successful completion of the diversion program. This section 9 has been troublesome. I did ask Ms. Samantha Eaton if she could give us some assistance, because what has happened is that the court has interpreted this particular section that put the child in a child diversion program, the child has to plead guilty, which I thought was within the interpretation that the court has. But the feeling was that if you put, how it would appear to a child or the public is that putting a child in child diversion is a penalty. If you plead guilty, then you go into child diversion, because if you successfully complete the program, the offense is still there. You can't withdraw. So what we want to be clear is that section 9, once you refer a child to child diversion and you say the child acknowledge that they have committed the offense, the idea is not for them to plead guilty and therefore have an offense recorded against them. The idea of accepting responsibility is that they know they've done something wrong and will participate
in the child diversion program. Now, there are two ways of doing this. You can say that the matter is referred by the constable or the DPP or the clerk of court directly without them having to go to court, and therefore there's no question of them pleading guilty at that stage. Because if they don't go through the program properly, then they may well have to be taken to court where a case may well be tried. Or you indicate generally, and this is how, Ms. Heaton, I don't know how you draft it, if the child goes to court or is taken to court, let us say for one of those offenses which may not be in the schedule, and we need to be able to say that even if the offense is not in the schedule, that the court can still accept recommendation for the child to be sent to child diversion. But even at that stage, you would like the child to at least have the opportunity to go through the child diversion program. And if they successfully complete it, then we hope that would be the end of the matter. The child would not have an offense recorded against his or her name. So the only time the child would really have an offense recorded is where the child, all the attempts and trial to get the child to complete the child diversion program has failed. So the court is then told that, you know, we have tried, but the child is not cooperating, the child is, and at that stage, you may well have to admit to the court that after 6 months, 12 months, you know, the court may well say after 6 months, try again. You know, but maybe there comes a point when you literally have to admit to the court under all the plans and programs, which we hope won't happen, but you have to see that possibility. The child is taken back to court and, in fact, will have to be tried as the case may be. Okay? So we need to look at that, Ms. Eaton, to see how we can have a program where for 99% of the cases, the child goes through a child diversion program and hopefully successfully complete it, whether referred by the constable, DPP, or the court. But in that 1% of cases where the child diversion treatment doesn't work, the court will have to make a decision. Okay? It may well be that, unfortunately, even at that stage, the court may well have to say that child has to go to an institution because the behavior is just uncontrollable, as the case may be. Fine? But this program must try in 99% of the cases to ensure that we can assist the child. And I hope 100%, but there's always, you can't leave out the possibility that there may come a case where the court may well say, you know, you have tried and everything you have done, you know, they will have to rule. Okay? So that section 9 is, for me, is problematic. So we need to readjust section 9, hopefully to reflect. Do you agree, colleagues? To reflect, you know, that it is not to be it should not be a guilty plea. Yeah, yes, Ms. Eaton.
Thank you, Chair.
No, that's a comment to you.
Good morning. Thank you, Chair. Following up on your statements, Chair, I just wanted to bring to the committee's attention Section 9 of the Act. Because the child diversion, the provisions are highly interconnected. So, for example, to deal with the issue of acceptance of responsibility is going to necessitate consideration of a number of provisions. And I found of particular interest Section 9, which speaks to protections in relation to child diversion. Section 10, sorry. Mm-hmm. And Section 10 provides, so this might be one of the provisions that has to be considered in the context of what are the implications of an acknowledgement of responsibility, especially where the child is before the courts. So, for example, Section 10 speaks to any admission made, acceptance of responsibility given, or information disclosed for the purposes of child diversion shall be treated as confidential. B, shall not be admissible in any proceedings before a court or tribunal. 2,
A person shall not be compellable in any proceedings before a court or tribunal to disclose an admission, the acceptance of responsibility or information referred to in subsection 1, or to produce any document that contains the admission, acceptance of responsibility or information. And subsection 3 provides that a child's consent to participate in a child diversion program under this act shall not amount to or be treated as a confession or an admission of guilt for the purposes of any criminal proceedings for a diversion offense. So that's one of the provisions that we'd have to look at.
Well, you see, that is why when you look at Section 10, it is clear that accepting responsibility was not meant to be an admission of guilt. That's my understanding, okay? You wanted to come in?
If you permit me, Chairman, I actually interfaced with child diversion yesterday in court. And I'm wondering if this acceptance of responsibility, and I just need some assistance because I'm working it out in real time. And I'm saying children in conflict with the law would have meant that you were accused of a crime and charged, some charged, some on bail. The aspect about acceptance of responsibility, if you are already in conflict with the law, this thing about going to child diversion to escape the hard hand of the court, is this acceptance one where there is the acceptance ought not be about guilt, but recognizing that you are in conflict with the law and need a program that will steer you away from just being accused or finding yourself in a situation.
That is exactly the point.
I know. So I'm saying in terms of, when you hear Section 10, the opportunity to speak about, okay, I did it. Let's get there. That would be when you're in the program. And we are with your mentors, but I'm saying there are children who are maintaining that although I'm accused, although I'm in conflict, I didn't do it.
Well, you see, that is why Section 10 is, if we may say so, the most appropriate section in that, and that is why the DPP in particular recommend that it should end up in court, where the child is being brought to court and say, you accept responsibility.
Right.
Then automatically, if you accept responsibility, it looks like a guilty plea.
But I think what...
No, let me just finish. So that is why I'm saying we need to find a way to adjust Section 9. Firstly, that the referrals can come from the constable or the DPP, without the child having to go to court.
Okay.
So that, as I said just a while ago, the only time the child should be brought to court is where it is not in the first schedule. It is not in the schedule. In other words, the child may have been found with a toy gun and been charged for having a toy gun. At that point, the court may well say, you're sure it's a toy gun? Yes, and we caught the child with a toy gun or with a bullet. And in such a case, it might be one for child diversion, you know. And the court may well then say, yes, you admit that you had a bullet. But at that point, you don't want the child to be found guilty of possession of a firearm or a bullet. You want the court to be able to say, we do a program of child diversion, whatever treatment is, and if it is completed effectively, then the matter is dismissed. So you don't want it, as I think happens too often now, that the child pleads guilty and has a record. And, you know, that's not what I think we want.
I think we're clear on what we want child diversion to be, but I'm just thinking that acceptance is really the acceptance to participate in the program. And I think that's what I'm looking at, because I saw it yesterday. Yeah, the three boys that were adamant they didn't do anything. And before the judge, before everybody, I'm saying, listen, it's the program, how beneficial it is recognizing that you are in trouble. You are a child who is in conflict with the law.
You have been charged.
And you have been charged. Right. So we know the presumption of innocence, due process, and all of that. But at that point, what is it you're saying to their parents is that they must accept that they want to participate, they're ready and willing to participate in the program. And it may very well be when they get in the program on a Section 10, they are in spaces, they have their mentors, and they can, these children might say, look, I really did do this, and thank you for intervening. And because most times people are going to say they're innocent and because they don't want to get in trouble.
Well, let's face it. Everyone who has committed an offense
say I didn't do it.
The first defense is denial.
I never do it. Right. So that deniability shouldn't stop it.
So you see, this is where Section 10 is so important. You could discuss with the DPP, the clerk of the court, or the constable, we would like for you to go on a child diversion program. We're not going to take you to court. So if you acknowledge that you did it, then you can go on the child diversion program. But if you deny it, we have to take you to court. Right. We have to take you to court because there might be, evidence against you to show that you did it or you're responsible. So these are matters which the drafter will have to help us as best as possible. I think you get the point we're making, Ms. Eaton. Senator Scott Motley, you wanted to come in.
I wanted, Chair, to support what Member Buchanan is saying, because the troubling term that which is causing us some concern is the accepts responsibility. Section 10 makes it pellucid that it's not an admission of guilt.
Right.
But if we could either, as you said a while ago, have the draftsman look at how we can replace accepts responsibility or define what accepting responsibility means, I think that we would not have to be detained too much by that section.
You're quite
As
correct.
I said, Member Buchanan's suggestion is an excellent one. It's more accepts being brought into the program.
Right.
So I want to support that, Chair.
We'll have to ask the drafter to see how we can let that be the preliminary matters to be discussed with the constable or the DPP, clerk of court, but not a matter that, is before the court, unless, it is one of those offenses that is not in the first schedule. Ms. Wright, you wanted to come in.
Thank you, Chair. Good morning, everybody. I just wanted to quote our ministry from the presentation that we had done to just give, I think, solidify what acceptance of responsibility is. It was stated in the presentation by the Ministry of Justice and Constitutional Affairs that acceptance of responsibility stems from a moral or personal perspective rather than a legal one. Or in other words, where a conviction indicates legal culpability, it does not necessarily equate to personal acceptance of responsibility. So I think that's perfect in trying to explain the essence of what acceptance of responsibility means within the confines of the Child Diversion Act.
Well, thank you. So, to be frank with you, why we have spent so much time on this Section 9, this Section 9 is the one that really needs some adjustment. All right, continue with it.
To continue Daniel Barnes's recommendation, he's asking the committee to consider the continuity of eligibility for young persons who have attained adulthood before cases were concluded, and they're now not included in the diversion process because of their age of 18. So they would have committed an offense.
No, once the offense is committed up to age 17, it should be.
But it did not go before the court at that time. And so, they would have aged out. So he's asking for us to contemplate continuing the eligibility aspect for such young persons who would have aged out. But at the time of the alleged offense, they would have been under 18.
No, so somehow we need to just adjust so that once the offense was committed as a child, it can be a child diversion offense, even if the charge is laid when he or she is 18. Yeah. Okay? Let us assume that the child was 16 and a half or 17 and a half, but it did not come to the attention of the police until he was 18. Then the fact that it was done before age 18, then I think it should be. So we just need to make that clear.
Okay. Continuing with the Ministry of National Security and Peace, still on Section 9, referral to child diversion program. Part 1, pages 17 to 18 of your scheduled document, they would have made certain recommendations asking the committee to consider revisiting the term consent and how consent is obtained from a child. They're also recommending that the Department of Correctional Services or a juvenile correctional institute be empowered to refer a child to diversion.
We want to extend it to the DPP at the moment. But at one time I thought even about a guidance council, but maybe that's not appropriate. But if you say institution, couldn't they just use the police to do the referral?
They're focusing more on the post after conviction, and they're serving time in the prisons for the Department of Correctional Services to be able to access, or that juvenile to be able to access.
I'm not too sure that, what do you think, Ms. Clark, is that, well, I mean, this is one in which the child has I've been sent to a correctional service. They're asking whether they could do another program of child diversion. Would that be appropriate?
So from my understanding, we're talking about the children who've already been convicted of the offense. Once they're convicted, the Department of Correctional Services, as Minister Cuthbert Flynn indicated, they have their suite of caseworkers and so on, who can also provide the rehabilitative work that is required, but it is done within the confines of their facility. So they do have similar staff, but that is after conviction. And also, Minister, we want to take into consideration the victim. I know sometimes we talk about, because we're here for the offenders, but if we want to be balanced, and a victim, let's say at the onset, agreed and consented for the matter to go to child diversion, but for whatever reason, the offender decided that they wanted to go through the formal system. At the end, if they're convicted, just from considering the victim's point of view, I don't think it would seem like balance in terms of justice, because you have brought the victim through the trauma of having to go to court and everything, and at the end, you're going to refer the matter to child diversion. It's almost...
It looks more like restorative justice.
And it's almost as though the victim would be punished for the offender.
Yeah. So it's not appropriate for that. The correctional services should deal with that aftercare.
We're of the view that once they have been convicted and the option of child diversion was presented before, it would be futile to do it after conviction.
Okay. Good.
And moving right along.
Sorry, one second. Yes, Ms. Eden.
Thank you, Chair. Just in terms of what...
Pull your mic closer.
Sorry. Just in terms of what the text of the legislation currently provides for. So, for example, Section 38 in relation to a child who has been convicted, Section 38 of the Act provides that the court may make a suspended sentence order if the court is satisfied that a child has, having been referred to a child diversion committee for participation in a child diversion program under Section 34, has completed the program in respect of the diversion offense for which the child has been convicted and sentenced. The other matter, which is the child who is in the custody of the Department of Corrections, provision was, at the time this act was passed, as I had mentioned previously, there was a slew of consequential amendments that were done, and the Corrections Act was amended to insert a new Section 31A, which provides that where a young inmate is detained in a correctional center, the superintendent of the adult correctional center shall, in relation to that young inmate, have regard to the best interests of the child and cause a child care plan to be prepared. And the components of this plan are set out in the schedule.
So, Ms. Heatley, you will have to work how to get some, I mean, we have to bring into play what we are saying in terms of child diversion is only appropriate before conviction. Because 38 is actually saying you could give a suspended sentence, you know, which seems to be, there is some conflict. So we have to find a way, you see, my understanding and my view in a way, and it's open for discussion, we should not see child diversion as treatment as a penalty, after care, after conviction. We should see it as the reason for a child to go through a program to avoid a conviction. Isn't that my understanding? That's how I see the child diversion working. Not after you have been convicted or you serve a sentence or, my view, how I see it is that it is to prevent, if possible, a conviction. So you have been charged, and the likelihood is that you were charged appropriately because you did commit an offense. And if you're given the opportunity to go right, and you can proceed, and then the charge can be withdrawn by the DPP in particular, and therefore doesn't go to court for conviction. You see, so somewhere we need to reconcile, Ms. Eaton, how we deal with that. I don't think the act should be one where child diversion comes in after you have been found guilty. Because then, although it is appropriate, I don't know, Ms. Clark, whether you think that, 38 is given the impression that a suspended sentence can be imposed if the child has gone through a child diversion program. And I mean, what's your view on it?
So as it is now, Minister, the Act allows for consideration after conviction, but what we're saying from our operations and understanding not only restorative justice, but the victim services component, it would be futile, because if you're trying to prevent reprisal and so on, if you have a matter that is brought before the court and the options are presented and they are not taken up, and the matter goes through the formal judicial proceedings, then at the end, this is being presented to the victim, that might just seem like, for lack of a better word, a slap in the face, and the consideration of reprisal that we have been trying to avoid through restorative justice might now become an issue that we need to consider.
You see, there's no doubt in my mind that restorative justice would be the appropriate thing if there's a conviction. That's my view. Restorative justice could be the appropriate thing. But in terms of child diversion, I don't think it is appropriate to have a child diversion treatment if the child has been in fact, if the child has been convicted. I'm not too sure why would he or she want to go through a child diversion treatment. You understand? Maybe because it's a lesser penalty than going to prison or, have a suspended sentence. So it is something that we will have to consider in the discussion. My position is that the child diversion program is appropriate to avoid a conviction. That would be and I think we should so provide the act that the act only deals with where a child accepts responsibility and will go through the program to avoid a conviction. Okay, that's the position, Ms. Eaton. All right, continue.
So just for clarity, Chairman, just wanted to make sure, because I believe what Ms. Eaton is also saying is that the Child Diversion Act of 2018 already have the provision in it for the post-conviction for child diversion. So is it the decision or the recommendation that the committee is looking at to amend this act to remove that provision? The committee is of the view that it is only appropriate for pre-charge, charge, prior to sentencing activity, because then there would have to be some amendments to this act.
Well, this is the point. This is the point, and I mean, colleagues, you see, I don't know if you see, there is a dichotomy there, or there could be inconsistency, because my view is that the child diversion is to prevent a conviction. But one is getting the impression that it can also be post-conviction. And I'm not too sure if that is appropriate. Could we ask Ms. Wright? It doesn't make sense to me.
I thought the legislation had a transition period. When it came into effect, it contemplated persons who already were going through the system. And a part of this amendments that we're doing is to remove that aspect of it. Because certainly the legislation is to prevent from the beginning any possibility of conviction. So we did say previously that we would have been removing any verbiage that would seem to suggest that the convictions was a part of it, or recommendations for child diversion.
Okay.
Right. So we have to see it that way, okay? All right, continue.
So we continue still on
Sorry,
the section.
no, we dealt with her. Yeah.
Still on the section 9, as we had contributions from 10 stakeholders or contributors. The Ministry of Justice and Constitutional Affairs, Part 1, pages 17 to 20 of your schedule. The ministry asked the committee to consider clarifying the legal threshold for referral as it relates to sections 2.3b and section 9.2 to align reacceptance of responsibility. I will pause here to allow Mrs. Cole-Jarrett to just remind us of what section 2.3b and 9.2 refers to.
I think though we have dealt with section 9.
So section 2.3b.
And we have a fairly good position what we want.
Yes.
Now continue.
Okay, the other point is we're recommending that there be strengthening of procedural safeguard and the requirement for victim consent. Example, where offenses are victimless, should consent still be required? So we're asking for some
You can't get consent
level,
if it's victimless.
right, but it is generally written within the act, so we're asking to make amendments to have that be clear. The other recommendation that we're asking the committee to consider is guidelines to obtain the child's informed consent. And we are also asking the committee to consider defining what acceptance of responsibility means.
Well, you have got some guidance, huh?
Right. And on the point of expansion of the referral pathway, that is to strengthen the role of the prosecutors to make direct referrals. The Ministry of Education, Skills, Youth and Information on Part 1 of your schedule, pages 17 to 19, would have made recommendations as well for the prosecutors to have authority to refer a child to child diversion. So there was
we want to make that very clear that the DPP or the clerk of court, or the prosecutor, can make a recommendation directly. A referral, sorry.
Another recommendation that the Ministry of Education is asking the committee to consider is to include the requirement for the presence of an advocate from the Office of the Children's Advocate, and if the child is a ward of the state, then a representative of a government agency with responsibility for children to be present where a child is to give consent. Also,
all of that is something, I'm not too sure we need to put it in the act, but if possible, so that when the DPP or the police is considering a direct referral, they may well want to consult with the relevant agencies or representatives, okay?
The other point they would have asked the committee to consider is where children are referred to child diversion, that the child not to be detained in a lockup, remand center, or correctional institution, and that the child is to be informed in age-appropriate language of his or her right to legal representation before giving consent.
Yes, yes. One second. CPFSA.
Just to expound on this, because when they are locked up in like Metcalf or South Camp and they come before the court, and the idea of diversion is put forward, the judge rejects it because they are already remanded in a correctional facility. And the correctional facilities are saying that they will not allow child diversion to come into the facility to conduct any parts of the program. So a lot of the children who might be there and locked up in the remand centers, they lose out on being a part of the child diversion program.
I think that's a very good point. Maybe we could ask Ms. Clark or one of your child diversion officers, have you had situations where the child is referred to child diversion but is actually locked up?
Yes, Mr. Chair.
How do you deal with the child who has been, I mean, for one reason or another, is in an institution?
Usually we correspond with the superintendent of the institution and get permission to come into the institution to speak with the child.
But it just seemed to me that it is very unfortunate, I mean.
Most unfortunate. Yeah. And in fact, I have a situation that the matter is now dealt with where the child was in the institution and we weren't even allowed. The times that they're asking you that you can come are just not feasible times to do anything. They have very strict rules. So in fact, it doesn't make sense. The child loses out totally on child diversion, that anything like that.
Well, this is the concern which we need to address. I think it should be in the most unusual case that a child should be institutionalized, being charged. I would urge, I don't know how we're going to put it in the act, but certainly we need to urge that a child, once they've committed an offense, at the earliest possible time should be referred to child diversion officer. You see, because what is happening now, unfortunately, is the child having committed an offense, they're charged and then they are in the lockup for a week or two before they're taken to court. Now, what we would want, based on what the DPP has said, is for the child, yes, the child has committed an offense, that they could be charged as early as possible, but the DPP or the constable must make a quick recommendation if it is a child diversion offense, okay? So that the child spends little or no time in a jail cell. I mean, I can just imagine how abhorrent it is for a child to be in a jail. So somewhere along the line, we need to find a way to say a child who has committed a child diversion offense, which is that they should be charged at the earliest possible time, and the constable or the prosecutor should make a determination whether they would recommend or speak to the child diversion officer so child diversion treatment can be dealt with right away. But it should be available within hours, you see. I mean, because what happens now, unfortunately, is when a child has been charged, sometimes it is for, yes, it might seem like a serious offense, but if it is a child diversion offense, I don't think the child should be institutionalized. However, if it is a serious offense that could be recommended for child diversion, then the DPP or the prosecutor should get the matter to court as quickly as possible if they intend to recommend that it go to child diversion, okay? So that, you see, I hate to think that, you know, that we're locking up youngsters in jail. And what is happening?
Chairman, the truth is that it happens and has happened. I have personal experience of a little boy who was in a situation with the courts, remanded to custody. Matter is in St. Anne. For him to be locked up, he had to be sent to Alexandria. That is like 2.5 hours away from the St. Anne's Bay Court. He was a premature child, he had asthma, his parents just happened to have an unfortunate officer not allowing the mother to see the child, can't see the child, don't get medication, all of that. That is a reality. And we have to recognize that even as we put things in black and white, you have to know if this is the aim we have. There has to be a way where the court insists, if it is that the child is to go in, that the child doesn't move from there until that the child diversion officer comes to the ear or something. The child at 11, put in a place, was there for 1 week before they got back to court. And mother not allowed to see. Mother lives in St. Anne, so by the time they tell you to come, it was not the visiting time, it was and the child is traumatized and locked up. So it makes a mockery of an act that you pass if it cannot, in fact, help the children. It's just paperwork at the end of the day.
Senator Donna Scott Motley, you want to come in, and after that, Ms. Eaton.
Thank you, Chair. I really wanted to find out from Ms. Clark if there is any kind of relationship which the child diversion officer or committee has with the police station. Because my own view of how this should work is that before the child is charged, a child diversion officer should have an opportunity to interact with the police. Because I think that our intention should be to prevent the child from being charged and that the child goes into the program rather than to have the other layer
the truth of the matter,
the child going before the court, being charged and then diverted. So I wondered how we could establish some sort of mechanism that immediately that the report is made, then the officer, a child diversion officer, is brought in.
Unfortunately, though, Senator Scott Motley, the law provides that the referral comes after the charge.
Yes, and I'm wondering if we could look at that.
Right.
If there's a referral, because Minister, you in particular, you have been speaking about the fact that we need to be in schools and all the interventions which the Child Diversion Committee should be able to make. I think we have come down to recognizing that that is not the role of the Child Diversion Committee. But what I'm seeking to do is to make an inquiry as to whether or not we could incorporate your own recommendations and suggestions into the legislation, which would allow us to achieve the intent which you have been speaking about. That is to say, avoid the child going before the court.
No, I'm firm on that. We're going to do everything to avoid the child going to court, you know, and take up the court. A lot of time is spent in the court with children, you know, which can be avoided. Ms. Eaton.
Thank you, Chair. I just, in keeping with the discussions, the deliberations of the committee, I found of interest section 2.3, which actually states, this act shall be interpreted and administered so that the best interest of the child is the paramount consideration, and in accordance with the following principles. Criminal proceedings are not to be instituted against the child if there is an alternative and appropriate means of dealing with the matter. And B, unless the public interest otherwise requires, and subject to this act, any child who has committed a diversion offense and accepts responsibility shall be considered for admission into a child diversion program.
Chairman, would you be kind enough to open Minister's mic? Thank you.
Yeah, go ahead.
No, I'm saying thank you very much, Miss Eaton. She's an excellent drafter and she knows what is there. And what this section has said is exactly what was done. And it therefore underpins the point that your child diversion committee and officer needs to A, know the act, B, be on the ground, B, be in touch with your police station, with your courts, with everything. And so that if something like that occurs, immediately she goes to court, this child should not be before the court, something. So the emphasis now has to be on your officer who is in the parish, to know the rights of the act, to be talking with the police, and to be aware of what is happening, because the act provides for it. And the Ministry of Justice had taken it into account, and it's right there.
Yes, yes.
Thank you.
All right, thanks, Minister Dalrymple. Go ahead, Ms. Miller.
All right, so I wanted to respond to the question from Senator Motley. So the police referrals, the child diversion unit overall, we are in contact and in close communication with the police. They're also members of our child diversion committees. Over the last fiscal year, we went out to almost all the police stations because we do know that they have rotations from time to time. We conduct sensitizations with the police, and we also provide them with there are the referral books that they use. Outside of that, too, we accompany them on they have activities where they go out on the road from time to time. We're a part of those activities in the parish. And if a police officer, you'll hear from time to time, a colleague will say, you know, I'm going to the police station just to provide some clarity or to pick up referrals. Because we do get a lot of referrals from them. And if they're not clear on something, they usually call the parish officers and ask for guidance, and the officers will provide that guidance.
Right. You know, Ms. Eaton, and unfortunately, we see the inconsistency in the Act itself. Because, first of all, Section 2.2 sets out what should happen. But then you go to Section 9 and Section 38, you just get the impression that it is quite inconsistent with what Section 2.2 is saying. So I say, Ms. Eaton, looking at Section 2.2, which is what we have been saying should happen, only to be confronted with Section 9 and Section 38 and how they have been interpreted. So I would say if we stick to Section 2.2, everything we have been saying here, you know, should be incorporated. All right? And I don't know, I'm not a drafter, but it's a challenge for you, Ms. Eaton, to see how we can get that done and remove some of the inconsistency which seem to appear in the rest of the Act. Yes,
And just for clarity, the matters that come from the police are cautioned. The offenders are cautioned. They're not charged.
Okay,
so
good.
Only the matters that come from the court are
where they're charged. Yes. But then even if they're charged by the police or whoever, we're hoping, as the DPP has said, that the DPP can make a recommendation after the charge. So police caution or charge, DPP charge, and if some actually ends up in the court, we want to say and urge a court not for a guilty plea to be imposed, but if it is an appropriate case, regardless of the offense, that it can go to child diversion to see if the best interest of the child can be protected. Continue, Ms. Wiggum.
We have three more contributors. The Office of the DPP Also ask the committee to consider that they be empowered to refer matters to child diversion. Jamaicans for Justice, on the Part 2, pages 19 to 21 of your schedule, also recommend for the DPP to be authorized to do direct referrals. The Children Foundation have recommended to the committee that where there is an agreement to participate in restorative justice measures, informed consent of the child and parent should be evident. Special provisions where a child believes he or she has not done wrong, that we delete section 92A that makes reference to acceptance of responsibility. I'll go on. Just to say on the 9 that the Jamaica Umbrella Group of Churches asked the committee to consider making mandatory diversion for pair cases where there is no evidence of coercion or exploitation, and that there should be clear prosecutorial guidelines to ensure consistent national standards, that there is no arbitrary charging or decision making. The Jamaica Constabulary Force, on the schedule, Part 2 of your schedule, pages 19 to 21, they have asked that where both parties consent, where there are both parties are minors, consent should be freely given, and also that the same exception that is applied to a child who is a child victim who is 14 years or under, that same exception should apply to a child offender per or in keeping with section 32(3)(a) of the Child Diversion Act. I don't think they want me to read that part. As it relates to section 10 that was discussed earlier, which speaks of protections in relation to child diversion, 4 contributors asked that this provision be strengthened to protect the rights of children in child diversion and to ensure that there's retention of records or how it is retained to ensure privacy. Also, as it relates to acceptance of responsibility, that it should not at any point in time be seen as admission of guilt, and that there should be legal representation present. The parties, or the 4 contributors, are the Ministry of National Security and Peace at Part 1 of your schedule, pages 23 to 24. They ask that that there should be to specify up to 18 years that the records are retained, and to clearly establish a proper destruction or disposal of said records. The Ministry of Justice and Constitutional Affairs, Part 1 of your schedule, pages 23 to 24, also asks that you consider amending section 10(3) that speaks of participation in child diversion or acceptance of responsibility being not a confession or admission of guilt. And Jamaicans for Justice, at Part 2 of your schedule, pages 21 to 22, ask for the inclusion for legal representation or an advocate at section 10(4) of the Act.
So I think basically most of what you have done so far is an assessment of section 9, right?
10.
So, and basically we acknowledge that section 9 is problematic, so the draft is going to reflect much of what has been recommended, okay? So continue. What page are you on now?
We're at Part 1 of your schedule, page 24, Daniel Barnes, as it relates to inclusion of eligible young persons, which would have said before. Part 1 of your schedule, pages 24 to 28, or we're at section 11, looking at the effect of child diversion program. And the comments from Daniel Barnes at page 24 of your schedule asks that the inclusion of eligible young persons be incorporated in that section. The Ministry of Justice also asks that there should be a distinctive framework provided for post-conviction, but I think that point is now moot. Right. The ministry also asks for clarity as to the proper procedure for disposal of matters and for the applicability of Section 11 as it relates to suspended sentence. The Office of the Director of Public Prosecution, at Part 1, pages 24 to 25 of your schedule, asks that there be outlined a method of how matters are disposed of, and that caution, and they also caution the committee to consider that a guilty plea usually leads to sentencing, and so how it is represented in the Act, the committee should give further consideration. We're at Section 12, duty to make reports. That's Part 1, pages 28 to 29 of your schedule, which includes the recommendations of the Ministry of Justice and Constitutional Affairs, the Jamaican Psychological Society, and the Jamaica Umbrella Group of Churches. The Jamaica Umbrella Group of Churches, they're asking that annual data reporting be made to the Parliament.
Just note that we do that.
The Jamaican Psychological Society asks that at Section 12 that we include language speaking to the use of psychological indicators. Section 13, speaking to ineligibility for child diversion, 3 contributors, so the clarification of the Joint Select Committee as it relates to what is an eligible or ineligible criteria, and also the need to look at the commencement date for referral to the child diversion program and how to treat with repeat referral in the program. The Ministry of National Security and Peace at Part 1, pages 29 to 30, and the Ministry of Justice and Constitutional Affairs both sought clarity on the date of commencement, and in terms of ineligibility, if an offense has been committed within 3 years from the date of commencement, the Ministry of National Security asks that where there are 3 referrals, that there should be a proviso that specifies to each offense. The Ministry of Education, Skills, Youth, and Information at Part 1, page 29 of your schedule, in relation to Section 13.1, asks that we reduce from within the 3 years requirement to 18 months.
Is that, you mean, sorry, repeat that again, Section 14?
Section 13.1, which reads,
child may no longer be eligible to continue in a child diversion program.
But, sorry.
Section 13, Minister. So just for clarity, for participation in a child diversion program, if the child commits or attempts to commit another diversion offense or any other offense within 3 years after the date of commencement of a child diversion program.
I don't know what members think. Yes. What I think Ministry of National Security is suggesting.
Ministry of Education.
Education. Maybe CPFSA can help us. But it's clear that the child may have committed 1, 2, child diversion offense, may have gone on the treatment program, and then what is being suggested that within 18 months, if they commit another one, that is beneficial to say that instead of waiting 3 years, after 18 months, they could still be referred. So I don't have a difficulty saying that if after 2 years, to give you a good example, if after 2 years the child commits another child diversion offense, you see, in all sincerity, Section 13 is intended that this is not a regular activity, to come for the child to go through this regular activity. But we can't ignore the fact, that there are some children who are recalcitrant and who will, need this treatment on a regular basis. And it may well start out as a 14-year-old. And, for one reason or another, they engage in behavior. I mean, with due respect, you might say that, drugs, let's just say smoking, that they were charged and they were told to stop it because, I don't have a problem saying the child can be referred more than once, so I wouldn't disturb it for the moment, All right, so I wouldn't disturb it. And I think, in fact, even that particular, if the child has successfully completed a child diversion treatment, and let us say the committee signs off that the child is now okay after the program, and another year time, they commit a different offense, another child diversion offense. I don't think we should prevent them from going on another child diversion. So I would adjust it to say that once a child, it's a different matter if they have not completed a child diversion offense properly. That, I don't know what members think, but we can't give up, I don't think we can give up. Yes, I'm coming. So I think somewhere along the line, we should adjust this. I don't even think we should put in this section. I think this section really should be removed and, let it be administrative, whether or not we are successful or not. Before you, Senator Golden Campbell. And then you, Ms. Wright, after that.
Thank you so much. Chair, a couple of things. And just on your last suggestion, other difficulty I have with leaving something like this to administrative direction, and I understand where you're going with it, is that, it may, at the end of the day, put us in jeopardy of treating with children in an inequitable way. And I say that slowly and guardedly because certainly there is no real one-size-fits-all approach to treating with a child. But I am curious to know, in looking at the propriety of this provision, what and the team may have put it before the committee previously. Please forgive me if I'm asking you to repeat. But I would be curious to know what is the level of, if you want to call it it's a word I can never pronounce, recidivism that we're seeing with children who have gone through the program, and in what circumstances are we seeing that in terms of the types of offenses? Would the team be able to opine on that? And if there was a document that you had put before us before, would you kindly direct me to it?
All right, I'll ask the team in a second. Ms. Wright, before, Ms. Clark, could you let us know answer that question from Senator Golden?
Thank you, Chair. I just wanted to know if Julia had mentioned that one of the recommendations in relation to Section 13 was for it to be repealed. That was something that the Jamaicans for Justice group had recommended, and I just don't know if I had missed it, and I wanted to put it out there for the committee to consider. So it was a question.
Okay. Good point. Ms. Clark?
So currently what obtains, I want to answer that portion first because I do not have the statistics on me, but I can share them with the committee at a later date. But what I want to make clear in terms of recidivism, the Act says that the child may no longer be considered. As such, the committee is allowed to discuss that discretion. So depending on the behavior of the child and, if we see that it is progressing more seriously, and so on, the committee can then decide if they want them to continue. The issue that we have, though, or the challenge is that because there is no stipulated commencement date in the Act, we internally have decided that the commencement date for the program is once the child has signed their individualized diversion program. However, what we've found in the last couple of years is that a lot of children are coming to the program. Let me not say a lot. Children are coming to the program who have been referred for matters, and once they start the program, or even before they start, let's say we do the intake assessment, it comes to our attention that they're before the court for another matter. For those children, as mentioned before, we always allow the committee to be informed about what is happening, and then a decision is made. But in order to help us to be very clear on what is happening, we would definitely want for the commencement date to be stipulated. And not only the commencement date, while we have no issue with the participation in the program 3 times, we want clarity in terms of what is 3. Because 3, some matters come with different, so they might be referred once, but with a number of offenses, or is it a case where they're referred and they come back another year and so on. For those matters we do treat, but the clarity would really help us.
Well, could you answer Senator Golden Campbell directly? In the last 3 or so years, have you had children who have completed the program but keep coming back? Have you had many cases of that?
We've had cases, I don't want to say many, but we've had cases where they have completed the program, or even just about, they've completed the requirements, but the committee has not signed off on their completion, and they are now returned for another matter.
For another matter.
So we've had some of those cases.
But to the best of your, you have had quite a few thousands of cases in the last 3 years. And as I understand it, virtually 80% of them have successfully completed the program.
So over 80% are compliant, Minister.
Right.
Yes. Just about close to 50% complete the program every year. And that is because the program cannot be, there's no timeline that can be attached to the program because of the risk level that we see for the child and the interventions that are provided. But in terms of compliance, we do have a high compliance rate.
So you're saying that in respect of maybe 6, a dozen, 20, what figure would you say that these persons who have gone through the program have actually committed another offense and would need another treatment, another diversion referral? About what figure, as a guesstimate? Because that's what.
Can I interrupt you a second, please?
Sure.
I appreciate you drilling down on my question.
Yes.
What I don't want, I'm trying to save our team member here, because what I don't want you to ask her to do is guess. If that data is available, would she please provide it to the committee? I certainly would wish to look at that. I too am of the view, having raised a few children myself and still in the process of doing that, I don't know any lesson that I've taught once that has stuck. You normally have to repeat the lessons a few times before it sticks. And some of them you have to put on a recurring, manufacturing line, so that you're repeating it periodically until they leave your house. So I am not one to say that there ought to be a limit on how many times a child engages the program or is required to engage the program. What I would appreciate, though, is, one, the data as to how often are you seeing that kind of recidivism. What are the offenses that you're seeing being repeated? And also, if perhaps you could do this part now, could you engage us a little bit on when a child comes to the program a second time or a third time, how does the program they're exposed to and required to participate in differ from the first time around? Are we simply repeating the program with them, or does there become a more engaged, a different approach, an approach now in consideration of the fact that they're repeat offenders? How does that differ? And could you give us a little information about that? Thank you.
Okay, thanks, Senator Gordon Campbell. Yes, sir.
Thank you, Chairman. I would recommend that we take the approach that Jamaicans for Justice said, that we repeal this. Chairman, we've gone into the whole internet days, but when I was younger, they used to have a cartoon, Dennis the Menace, and Mr. Wilson.
You learned a lot from that, right?
I learned a lot, but we're talking about it now, and there is no hard fix. For instance, a child who participates in smoking or something like that is diverted for the smoking. But then he finds himself like Dennis the Menace, and he throws his baseball into Mr. Wilson's window. That's destruction of property. The two don't march along, and the diversion is different. And he may pick up something else, so he learns through experience. And you're only a child once between the age of criminal responsibility, 12 to 17, when you age out. If we are saying that you get three strikes and you're out, those laws never work. Right. So for me, I think that it's not, I can't even at this point say a case-by-case basis where you take the child as you find them. But in this very committee, we did learn that here we recommend for child diversion, but the child is locked up. We recommend for child diversion, he doesn't or she don't have bus fare. It's not her fault. She's from a community where violence is high. She can't come to the program, and the program is not successful, not because of the child, but because the people he or she depends on to get to the program. We have to be a little bit more to say that they must get access to child diversion as long as they're a child.
Right. You wanted to say something, Ms. Clark?
I just wanted to answer the question that was posed, but I also want to confirm that while we don't have an issue, it's not a 3 strikes and you're out. We want to consider also the resources and the impact. So if you're doing something over time, and the impact is not there, then we might have to consider another option.
Sure.
But for children who have been referred to the program, and let's say they are sent to another referral is sent within, if it is within the 6 months window, we don't normally redo the entire intake process. We try to, because usually for social services, over 6 months a lot wouldn't change. We find out though, if things have changed and if it's a matter that is referred for something else, we consider that and we present it to the committee to say, okay, this child was being treated for by the National Council on Drug Abuse for drug use and so on. They have now offended.
Or whatever.
Yes. So we are going to be exposing them to maybe mentorship, or the committee can review the treatment plan that is there and indicate if they want it to be modified. Usually once that is done, or the court too can indicate, okay, this child is sent for X matter and we want the program to include this specific intervention for them to be treated with,
right,
because they're already being treated.
There's no doubt I get a consensus that we should remove Section 13. As far as I'm concerned, we have to keep trying. But apart from keep trying, it may well be that the Child Diversion Committee says that another referral is not to be engaged in, because let it be administrative rather than legal. So that to the extent that the Child Diversion Committee or the Child Diversion Officer can say that we have done 6 times with this child and it is not working. But so it's administratively, the Child Diversion Committee can say, having done 6 times of treatment, we're not going to continue with the child any longer. So it becomes more administrative rather than legal, legislative. So I would remove the legislative Section 13 and let it be the direct intervention. And it could be after 4 or 6 times, you give up. But I think we must keep trying to, in the best interest of the child, require that we keep trying. That's my view. Senator Golden Campbell, you wanted to come in again?
It's precisely matters like this that I keep calling for us to look more carefully at data, okay? And I say that because it seems very logical and it seems morally and emotionally correct to simply withdraw that provision from the Act. But as far as I am aware, the child diversion program does not enjoy unlimited resources. And so the question that I have is, when a child goes through the program once, twice, 3 times, does the state continue to quote unquote try with that child at the expense of another child who may be referred to the program for the first time or may be referred to the program for the second time? Unless you're saying to me that the program has unlimited resources for us to be able to do this, then while I do not believe that there should be any giving up on any particular child, we have to acknowledge how much of the state's resources are going to be committed to one child at the expense of another. And so I wish again to call for us to look at the data in respect of recidivism, in respect of the type of offenses that are being repeated, and in respect of how many children may have exceeded the current statutory times that they can do the program and are now then, we are saying, under the current legislation going to be barred. We must look at that to determine whether or not it makes sense for the state to commit in an unlimited way to a particular child, because it may in fact jeopardize our protection and care and our diversion of another.
Well, I must say, Senator Golden Campbell, I have to disagree with you here. I think when it comes to a child, that as much as possible, we should try. So even if the data shows that we have 12, 2 dozen children who are committing 2 or 3 offenses, I just feel the act is in the best interest of the child. And if it means that the child needs additional, the only cost, Ms. Clark, the only cost to the state is really in terms of psychological support. We pay psychologists to do treatment, right? We pay for psychologists to do some treatment, right? Is that right? I mean, no, let me just say this. The program became overwhelming. We had 1 child diversion officer in every parish. Because of the numbers that were coming to the parishes, we have increased it to 2 diversion officers to every parish. Now, there's no doubt we're having a problem in the country. And if these children, if more children are being referred to child diversion, then the state will just have to put in 3 or 4 more child diversion officers if the program has merit to it. And to the best of my knowledge, the program has a lot of merit. It is assisting 4 out of 5 children most times. So it may well be that 1 out of 4, out of 5, is continuing the problems all the time. But I think it would be sad for us as a state to say we give up. I don't think we can say we give up.
I'm not advocating that we give up. I'm advocating that we make decisions not on the basis of what feels emotionally right, but on the basis of how the numbers and the costs that we incur as a state fall. That's all I'm asking for. I don't understand why every time I ask for data,
but what I was suggesting, though, Senator Golden Campbell, is that it should be dealt with administratively rather than legislatively.
And for the reasons, sir, that I set out before, I don't know that as a committee member I can agree with you without understanding the nature of the repeat offenders and who they are, what they commit, how many of them, how much of the budget of the child diversion program is consumed by repeat offenders. These are important matters to consider.
Let us delay this. Let us delay this decision until the next time and on the next occasion, which could be next week, we make a decision, you give us the data. How many of those children who have come on the program, how many have had a second or third occasion to be on the program for next time? And on that basis, we make a decision. Yeah, yes,
I want to say
Chairman,
one thing.
Chairman, before you leave me, can I just ask for one additional data point? And that is the annual budget allocated for the child diversion program, and whether or not the program exceeds its budget, goes under its budget, needs supplemental budget during the year. I'd like to see those
well,
numbers.
we can tell you right now. How much is the budget, Mr. Clark? How much is the budget?
I'd be grateful if we could all in the committee get that information in writing. Thank you.
But it's actually in the budget, you know, in the annual budget. But the main cost is the child diversion office.
It's for this year. It's over $80 million.
80 million
for this fiscal year.
For this fiscal year,
And
which
for
includes.
last year, what was it?
It was around the same, a little over $80 million.
80 million, which is the
Did you spend your
employment.
budget?
Sorry.
Was the budget exhausted?
What
Was the budgeted amount exhausted?
For last year, no. We went up to, I think, 80-something%, but we didn't exceed the budget last year.
And this is after not only
In
paying
some
officers,
areas,
but
yes,
also.
but not for the programmatic.
All right, but we can.
Chairman, can I please get that information in writing?
Okay, give us
Please.
a figure. Okay, all right.
Chairman, I understand senators' need for the data. It's not an objection to data. And I understand, you know, the thing of how much we spend and the state spend. But, you know, when you look at just a bit, I just thought, just off the cuff, we patched the road today, and tomorrow the rain fall, and government have to find the money
Please
to
don't.
patch it again, and patch it again. And for myself, you know, my concern really is, and I know what she's saying, I appreciate it, but like you, if it's children and we have to keep patching them up,
No,
they are our future.
We get some information for the next meeting. All right, continue, Ms. Wigan.
We're at section 14, which speaks to the child diversion program. We had 8 contributors who asked that this section be strengthened to design, implement, and deliver a better individualized child diversion program, albeit the 8 had different perspectives, including parental support. Daniel Barnes, starting with Daniel Barnes, part 1 of your schedule, pages 31 to 32. He asked that a new section 14A be inserted to treat with the parent-guardian requirement to attend meetings convened by the Child Diversion Committee. He asked the committee to consider that reasonable steps for the child's compliance be taken into consideration in the Act, and that there should be evidence of participation in parenting education, and to cooperate with, that is, the parents to cooperate with assessments conducted under the program. Because I think the point he was making is the absence of support from the parent side, that he would want the Act to try to incorporate to strengthen that aspect. Or 50. Yes. The Ministry of National Security and Peace, at part 1 of your schedule, page 31, they ask for the requirement of a mandatory case management system for all children referred. And as we listen to Member Golding speaking about provision of data, if we had a effective and proper case management system, we'd be able to provide the information in terms of empirical evidence at a quicker pace. Unfortunately, we are challenged, but I know Ms. Clark will try to accommodate that aspect of it. The Ministry of education, skills, youth, and information at part 1 of your schedule, page 31, they ask that for the deletion of the wording in whose presence the child consented be done as it relates to section 13 to allow for flexibility. The Jamaican Psychological Society at part 1 of your schedule, pages 31 to 32, asks for a number of recommendations, that is to include child's developmental level, that we should consider the child's developmental level. For example, where younger children have challenges with impulse control and moral comprehension, and so they ask that section 2.3b be amended to incorporate the requirement for acceptance of responsibility, be developmentally informed by psychological evaluation. And they also ask for the insertion at section 14.1b for wording to the effect developmental level of the child to be included in that section. The AIDS Healthcare Foundation Jamaica at part 2 of your schedule, pages 22 to 23, they ask that sections 14 and 16 include educational and counseling intervention, and to clarify the scope of such interventions. The Children's Advocate at part 2 of your schedule, pages 22 to 23, asks the committee to prohibit, I would have mentioned that earlier, the placement of children in child diversion program in correctional facilities due to the absence of suitable residential placement, and for the requirement that they be placed at alternative child protection or residential arrangements be made. The Jamaica Umbrella Group of Churches at part 2 of your schedule, page 22, asks for consideration to be given to the inclusion of early family engagement protocols and to have mandatory parental conferences be included, and for counseling referrals for the parents to be included. Sharika Lindsay, part 2 of your schedule, pages 22 to 23, asks for the incorporation of the reintegration of asks that the reintegration sessions be incorporated in the child diversion program. We're now at section 15. Mrs. Sandy Lou Cole Jarrett, she will continue with the overview. We had stopped at the last session where she should have reached section 14, completed that. So we're now at section 15 for her to do the overview, and then I will
actually we are going
with the matrix.
I think a number of members are under pressure with time. So we're thinking of stopping around 12:30. All right? And then, please, members, we want to go again next Wednesday at 10 o'clock. We really want to finish up. So please, members, unless there are objection, we're going to go next Wednesday at 10 o'clock. No, we can do as many virtually as possible, but hopefully members can be here to continue. You want to do, Ms. Cole-Jarrett, are you going to belong with that section? Go ahead, and you have another 10 or so minutes.
I'll try to be quick. So section 15 speaks about the minimum standards for child diversion programs. So a child diversion program developed pursuant or under section 14 shall be developed, administered, and supervised so that the best interests of the child are paramount. It shall take into account the public interest, utilize a restorative justice approach, be developed with a view to causing the child to understand the impact of the child's behavior on others, including victims. It should take into account the child's socialization needs, delivered in a location readily accessible to the child, be capable of being administered at various locations, circumstances, and for a number of diversion offenses, be structured in a manner that enables proper supervision of the child participating in the child diversion program, evaluation of the effectiveness of the child diversion program by the child diversion committee, be developed to take into account the needs of the children in rural or remote areas in the parish, and promote the involvement of parents and guardians as appropriate. So we would have gotten some comments from interested parties on section 15.
Four contributors commented on that section 15. They asked that the section be strengthened to allow for minimum standards to support child-centered, responsive, inclusive, and accessible diversion programs. The four contributors are the Ministry of National Security and Peace. At your schedule, Part 1, pages 32 to 33, they ask for the inclusion of provisions that treat with children with disabilities, to ensure that language is placed in the Act that requires access to the diversion program for children with disabilities, and also to have a specialized assessment for children with disabilities. Jamaica Coalition for a Healthy Society, Part 1 of your schedule, pages 32 to 33, they invite or ask the society, the committee to encourage, I'm not certain how in the Act would do that, but to encourage the youth to attend church, and also to encourage parents to play a greater role in their children's lives. The Ministry of Education, Skills, Youth, and Information, at Part 1 of your schedule, pages 32 to 34, asks for a number of recommendations to be considered, starting with the amendment to Section 15 that would allow for the minimum standards to include psychosocial and educational needs assessment as a mandatory component complementary to what the Ministry of Education is currently doing. That is their ongoing work in advancing school-based
Wouldn't you say that what is there covers some of that? I mean, what is in Section 15 and 16 cover most of what is being recommended? Okay, so go ahead.
Yes. The Jamaican Psychological Society, at Part 1, pages 32 to 33 of your schedule, asks that we increase the provisions in relation to Section 15 of the Act to treat with the use of trauma-informed approaches in child diversion. It is more detailed on your schedule.
Okay. All right. You want to, where are you now? That's Section 15.
Yes, we're finished with Section 15 now.
All right. Tell you what, we'll stop at this time, and then we continue from Section 16 next Wednesday. The rest of it is really not elaborate. So please, colleagues, everyone on virtually and here, we're going to continue next Wednesday, and we could finish the matrix and the overview, and then we can make some decision then, and maybe even another meeting. But colleagues, can I just beg you to... You want to confirm? Excellent. So, Mr. So for the first three, what here? What? Just Mr. Nash, could you? We just want to confirm the minutes for. Give me the April. No, that is the one. No, they are not confirming the one that was issued for April 9th. They have the last three. You had three of them last time. What date? Just give me the dates. But I thought they were confirmed. Yes.
Anything that was brought.
No, so the one now that is needed for the next Wednesday is this one that you have, the 9th. April the 9th, okay? And then you have some others now to come. If you have one or two others, could you issue them for me so we can try and all right. I want to thank members for being here. We have done 2.5. I think we got through a fair amount. Still a fair amount still to go. And my concern is that we really would like to finish the committee during and get a report out before the end of July, okay? So next week we can finish, and then maybe 1 or 2 other meetings soon after we finish everything that has to be dealt with. Okay? So with that, I adjourn the meeting until next Wednesday at 10 o'clock.
Speeding kills. Obey the speed limit. A message from the Road Safety Unit in the Ministry of Transport and Mining.
Hi, boys and girls. My name is Mr. Badan. Welcome to guidance class. I'm your guidance counselor for today. I'm from St. Michael's Primary School. Last week, or the last class we had, we spoke about hygiene. This week, I want to talk to you about puberty. So I want to talk to my older students. I want to talk to my students who are in grades 5 or 6, or you may be in a higher grade. I want to talk to you today about puberty, understanding my development. That's what we're going to be talking about today. Wait, what's happening to my body? I'm getting thicker, or my voice is getting deeper, or for girls, my breast is getting larger, or my waist is broadening. You will see different changes in your body as you age, and that we call puberty. Puberty now is the time of change from child's body to an adult's body. Doesn't mean that you are an adult. It means that your body is maturing. It also means that you are experiencing emotional changes. And boys and girls, your body develops and becomes fertile. No, your changing body is something that people don't like to talk about. When we talk about these changes, it normally feels, or it is normal rather, to feel curious. What does sir mean? Or to feel disgust. Ew, sir, don't talk about that. Or to feel comfortable. Or to feel shy. You don't want to talk about it at all. Or to feel embarrassed because you may be experiencing certain things. Or some people will feel excited because of what we're going to talk about today. Guess what? It is normal to experience any of those feelings as we talk about puberty, because puberty is normal. So, when does puberty begin? For boys, puberty begins from the ages 10 rather to about 15. And for girls, ages 8 to 14, and sometimes a bit earlier from age 7 to 14. Everyone is different. Say that with me. Everyone is different. Yes, that means we all won't experience or puberty rather, at the same time or at the same age. No, everyone will start and finish at a different time, and that is normal. So your friends might be experiencing puberty before you. That doesn't mean you are weird. It is normal. We all won't be at the same stage at the same time. No, there are some changes that occurs in our bodies for both boys and girls. Do you know some of those changes? Let me share some with you. Your hair grows. You grow pubic hair under the armpits. You grow pubic hair rather, and then you grow hair under the armpits and even on the face. You get more hair on your arms, right? Check and see if you have hair on your arms. On your legs, your chest, and your back. Not for girls. Boys usually experience those type of changes. Voice deepens. You start to sound like a man. I know. I had a student in grade 6. My last grade 6 class there is now in grade 7. And he came to me and his voice was deep. And I said, why is your voice so deep? I said, sir, remember I'm going through puberty and it is a part of the change. And I was ecstatic. Why? Because he could have, taught me what I taught him. And I was proud of him. His voice deepens and he knew that this was a part of the pubertal stage in his life. So boys, your penis and your testicles grow. Yes, the penis and the testicles, they grow, get bigger. That is normal. Yes, yes. Sperms is produced. Don't feel any way about that. That means your body is developing and it is healthy and normal. You may have mood swings. Girls aren't the only one that gets mood swings. Boys will develop mood swings as well. And other feelings. You will get other feelings as well. You grow taller. Some grow extremely tall and others just grow. That's all right. You don't have to be extremely tall. It's okay. If you're short, it's okay. You will grow, and where your body feels to stop, it will stop, and that is normal. Remember, everyone is different. Breast for females, your breast enlarges. Your waist gets broader, and menstruation starts to occur. We call it period. That's the other word. You start to see your period. That's why we encourage our females to talk to our mummies or grandmas or an older female in the family to help you understand the period cycle. Bones and muscle grows for both boys and girls. Weight gain is normal. Look here, it's normal if you put on a weight, don't feel no way about it, right? You will lose it at some point. But females, it is normal to put on a little weight while you're in the pubertal stage. Your hair and your skin becomes oily and you may get pimples, the bumps all over your face. And that is normal. That's why we got to watch what we eat and what we drink. You don't want to eat a lot of fatty stuff with a lot of oil, and you don't want to drink a lot of sweet stuff with a lot of sugar, because that contributes to getting pimples on your face. But it will go away. You won't always have pimples. It will go away. Your body sweats more when you're in this stage of puberty. By the time you run to your bathroom or you run to your room, you will sweat. It's normal. It's okay. I had my students in my past class, by the time they run to my guidance room, they're sweaty. And it's okay. because they're going through the stage of puberty. So you might be sweating now. So just wipe your face. Yeah, pat and wipe your face. Because it is normal. Body sweat is normal. That's why in our hygiene class, we spoke about bathing and bathing regularly and using deodorant and ensuring that we dry off properly because we want to prevent odors, bad odors. And remember, perspiration does not give off a scent unless it is mixed with bacteria. So that's why we have to bathe properly